I stopped by my local gun shop the other day, just planning to grab a box of 308, and the suppressor display was almost wiped clean. Word had spread like wildfire. The Department of Justice had finally confirmed in court that suppressors are legally recognized as protected arms. Within hours, gun stores across the country were packed like it was Black Friday for tax stamps. Shelves cleared out, phones ringing nonstop. The whole industry went into overdrive. Hey folks, this is Tommy from the Armory, and today we're diving deep into what really went down after that Supreme Court bombshell, and why shooters, hunters, and even first-time buyers are rushing to stock up. Before we unpack the details, do me a quick favor. Hit that subscribe button and tap the bell icon. It's not mandatory, but every click helps keep this channel alive and motivates me to bring you more no-nonsense firearm content every week. All right, let's jump into what just shook the entire gun community. The legal earthquake. For years, we were told suppressors were just luxury add-ons. Cool gadgets that live behind NFA bars, wrapped up in red tape, $200 tax stamps, and months of waiting. Since 1934, that's been the law of the land. But suddenly, the very same Department of Justice that enforced those rules just flipped the script. In a federal case, Vanderstock versus Garland, the DOJ admitted on record that suppressors qualify as arms protected by the Second Amendment. That's not a rumor, not a leak. It's a written statement in a court brief, and that one sentence detonated across the gun world like a legal hand grenade. What forced this sudden reversal? Pressure from the courts, especially after the Supreme Court's Bruen decision in 2022. That case rewired the entire framework of how judges evaluate gun laws. Before Bruen, the government could defend restrictions by citing public safety data, crime stats, or fear of misuse. After Bruen, none of that flies. Now they have to prove any restriction aligns with historical precedent, meaning it must have existed in the founding era. And when it comes to suppressors, there's no historical tradition of banning or registering them. That's what cornered the DOJ and forced this quiet but massive legal pivot. Why the DOJ's admission changed everything. This isn't just a technical win. It's a complete shift in how the law sees suppressors. For decades, the government argued that suppressors weren't arms, just accessories, optional gear that didn't fall under constitutional protection. That argument is now officially dead. By recognizing suppressors as protected arms, the DOJ basically pulled the rug out from under its own previous stance. It means that restrictions, tax stamps, and waiting periods tied to suppressors could now face serious constitutional challenges. Think about it. If suppressors are arms, then making citizens jump through federal hoops to own one could be seen as violating the Second Amendment itself. That opens the door for lawsuits, and a flood of them are already lining up. Lawyers who've been waiting years for a crack in the system now have it. Gun rights groups are calling this a once-in-a-generation opportunity to roll back decades of overreach. Even manufacturers are reevaluating what this could mean for future designs, pricing, and production. In short, one sentence from the DOJ just rewrote the rulebook. The historical context. To really understand how big this shift is, you've got to rewind the clock almost a century. Suppressors didn't become taboo because of crime waves or mass shootings. They were swept up in the National Firearms Act of 1934, a law born out of fear and political theater. Back then, the Great Depression had left people desperate. Poaching was on the rise, and lawmakers panicked at the idea that poor farmers could quietly hunt game to feed their families. So they lumped suppressors in with machine guns, sawed-off shotguns, and other gangster weapons. It wasn't about technology or danger. It was about control. And for nearly 90 years, that narrative stuck. The irony? In many parts of the world, like Europe or New Zealand, suppressors are treated as basic safety tools, not sinister gadgets. Hunters use them to protect hearing, reduce noise pollution, and avoid disturbing nearby landowners. Fast forward to today, and we've got a system that still treats a simple metal tube like a threat to national security. That's the outdated mindset the Bruen decision and this new DOJ admission are finally starting to tear down. This isn't just about hardware. It's about recognizing how far we've drifted from common sense. Gun stores go wild. The moment that DOJ admission hit the web, Gun stores turned into madhouses overnight. Shelves that usually held suppressors were stripped bare within hours. Dealers were fielding nonstop calls. People were lining up before opening, and the supply chain couldn't keep up. It wasn't just hardcore collectors or tactical junkies buying either. Regular shooters, hunters, and even first-time owners wanted in before the rules changed again. Everyone knew something big was happening, and nobody wanted to be the last one standing without a suppressor. For years, the process to buy one felt like a bureaucratic nightmare. Fingerprint cards, ATF background checks, long waits, and that dreaded tax stamp. Now that people realize these devices are officially recognized as arms, the mindset shifted overnight. Dealers started reporting week-long back orders, and some manufacturers even paused online orders just to catch up. It's the same kind of rush we saw when magazine bans or ammo shortages hit. But this time, it wasn't driven by fear. It was driven by opportunity. Gun owners saw a legal door swing open, and they weren't wasting a second walking through it. Reactions from shooters and dealers. The response from the gun community has been split. Excitement on one side and disbelief on the other. Shooters who've followed the suppressor debate for years are calling this a constitutional correction. They see it as proof that the Second Amendment still holds weight in modern America. To them, this ruling isn't just about silencers. It's about finally reversing decades of government overreach. Gun shops, on the other hand, are overwhelmed but thrilled. For small dealers, this sudden spike in demand feels like Christmas came early. But behind the smiles, there's uncertainty. Nobody knows how long this window of freedom will stay open, or what kind of pushback might be coming from Washington. Meanwhile, manufacturers are ramping up production like never before. Some are already announcing new suppressor lines, betting that legal clarity will drive mainstream acceptance. Others are cautious, waiting to see if the ATF or Congress will move to tighten things again under a different pretext. Even within law enforcement, opinions are divided. Some officers quietly admit they support the decision, especially those who've seen firsthand how suppressors make range time safer. Others worry that the public still misunderstands what a suppressor does and fear a wave of political backlash. The bottom line? Everyone in the gun world knows this isn't business as usual. It's a turning point. What happens next? So where does this all go from here? That's the big question. Because this DOJ admission doesn't automatically rewrite the law, but it changes the battlefield. Every ongoing suppressor case now has new ammunition, legally speaking. Attorneys are already citing the statement as proof that the government can't treat suppressors like unprotected accessories anymore. We'll likely see a wave of lawsuits challenging every major restriction tied to the National Firearms Act, from the $200 tax stamp to the mandatory registration process. If even one federal court sides with that logic, it could create a domino effect that forces Congress or the ATF to rethink the entire NFA framework. And that has regulators sweating. The ATF has been tightening its grip over pistol braces, unfinished frames, and other gray areas. Now, with suppressors entering the protected arms category, their entire enforcement strategy could be on shaky ground. Some lawmakers are already demanding hearings, claiming this move could make dangerous devices too accessible. But others argue it's long overdue, that Americans shouldn't need government permission slips for tools designed to reduce noise and protect hearing. Make no mistake, this is just the beginning. The next year or two could redefine how the Second Amendment applies in the modern era. Closing thoughts. At the end of the day, what we're seeing isn't just a policy shift, it's history in motion. For the first time in nearly a century, the conversation around suppressors is changing from restricted device to protected right. Whether you're a range regular, a hunter, or just a law-abiding citizen who values freedom, this ruling reminds us that the fight for gun rights never really ends. It just moves to a new battlefield. But let's be real, the story isn't finished. The DOJ's statement cracked the door open, but it's up to courts, legislators, and everyday gun owners to make sure it stays that way. There will be challenges, appeals, and probably a few political storms along the way, but the direction is clear. The foundation of the Second Amendment just got a little stronger. So keep your eyes open, stay informed, and keep your rights sharp. If you found this breakdown useful, do me a solid. Hit that like, subscribe, and notification bell so you don't miss what happens next. I've got more updates coming as this story unfolds, and trust me, things are just getting started. This is Tommy from the Armory signing off. Stay safe, stay free, and I'll see you on the next one.